Hello, and thank you for watching. My name is Bradford Roberts, Principal Broker, Founder, and Owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. The eviction process in Nevada is very quick, primarily because Nevada is a landlord-friendly state, very different than our neighbors to the left in California. Right now, we have a new eviction moratorium that extends through the end of March 2021 as of the filming of this video. Who knows what's going to happen thereafter? I guess it depends on many factors, right? But the eviction moratorium that is now extending through the end of March does not include any kind of lease violations or nuisances, meaning that if someone is violating the terms of their lease for any reason other than non-payment of rent, or if they're creating a nuisance, they can still be evicted even during the eviction moratorium. And the eviction process all begins with the serving of notice upon the tenant. Now, what does it mean to serve notice on the tenant? It means to use a legally accepted manner of alerting the tenant to his status. So in Nevada, we can post a notice in a conspicuous place on the property, such as taping it to the front door as an example. We could send a certified letter. We could hand it to anyone in the house who's 18 years old or above. Those would constitute legally acceptable methods of service in Nevada. So that's what it means to serve notice, that we are providing the tenant with a document, letting him know exactly what his status is, that we intend to take some action against him, probably eviction. Now, after a tenant receives notice in the state of Nevada, he can always ask the court for something called a motion to stay. Basically, it's going to put a pause on the eviction process at that point until he gets his day in court. Now, there are many different types of tenant notices in Nevada, many more than I could possibly get to in this video. So for the purposes of brevity, I've decided to pick about 6 or so that are the most frequently used notices that we would serve upon a tenant. And when it comes to these notices, a lot of them have something in the title, 3-day, 4-day, 7-day notice, etc. I want to make sure we know how to count. I know that sounds pretty funny, but the number of days is actually based on judicial days. So judicial days means the days that the court is in session. And different cities, different counties, different jurisdictions have different court calendars. So when you hear something like a 7-day notice, as an example, you're counting 7 actual judicial days. So you're going to have to find out what days the court is in session in that particular jurisdiction. And of course, the day of service itself does not count. Okay, so let's get into the most frequently used notices. By far, number 1 is the 7-day pay or quit. 7-day pay or quit. Pay, you can probably figure out what that means. Quit means get the hell out of the house. And this one is used for non-payment of rent when a lease is in place, okay? The only time we could use a 7-day pay or quit is when there's a tenant with a lease in place and we are trying to get him out for non-payment of rent only. Second one I want to discuss with you here in this video is called a 5-day tenancy at will. A 5-day tenancy at will is used also for non-payment of rent, but in the situation that the tenant does not have a lease. If it's a month-to-month tenant or a tenant at will, etc., we would serve a 5-day tenancy at will. The third common type of notice that I want to discuss with you here is called a 5-day violation of lease. So this is going to be for something other than non-payment of rent. As an example, somebody's running a business out of their home, or they're subletting, which is a violation of the lease, or something like that. Then we would serve a 5-day violation of lease. And this is the kind of thing that can still be served, followed by an eviction, of course, during this current eviction moratorium as of the date of this filming. A fourth common notice is called a termination of tenancy and a 30-day notice to quit. Again, termination of tenancy and 30-day notice to quit. So this is when the landlord or property manager wishes to end a month-to-month tenancy, but the rent is not late, there's no violations, there's nothing bad going on, other than the fact that for whatever reason, the landlord wants to get this tenant out of the property, reclaim his property for some particular purpose. The fifth notice I want to discuss with you today is called a 3-day nuisance notice. A 3-day nuisance notice. And this would be used for unacceptable conduct, something like dealing drugs, gang activity, harassment of other tenants, harassment of the neighbors. Something bad is going on enough to rise to the level of being deemed a nuisance. And I also want to discuss number 6, a 4-day notice to surrender. A 4-day notice to surrender is used for squatters. And we can have a discussion about squatters. I know a lot of people think that if you call the police, they're automatically going to pull people out of the property by their collar. That's probably not going to happen, at least in most jurisdictions in Nevada, because the tenant is going to say, to the police that he has a lease, he can't find it right now. And of course, the police do not act as a judge. They're not trained attorneys. They're not trained to read legal documents. So we do have to go through the eviction process when there's a squatter in a property, unfortunately, and that would begin by the service of a 4-day notice to surrender. So those are 6 of the ones that are commonly used right now. As I mentioned, there are many, many more. There are some that are specific just to mobile homes, as an example. And all of these are available on the Clark County website. If you want to download them, you can download them for free. It's www.accessclarkcounty.com, www.accessclarkcounty.com. And I know for some of you, it's difficult to ascertain which type of notice you need to serve. So my recommendation is to either talk to counsel, or if you don't want to go to that expense, another thing you can do is talk to the company that serves process. So we use outside companies. I'm not going to mention any right now, but we use outside companies. You can Google them. And they're the ones that actually go out and serve these notices for you. You don't want to serve it by yourself. It can be a dangerous situation, right? So these are often retired or former law enforcement personnel who serve these notices. Go ahead and talk to them if you're confused about which type of notice to serve. So let's go back to the notices that I just ran down with you. So most of these notices, with the exception of the 7-day pay or quit, okay? With the exception of the 7-day pay or quit. The other ones are followed by something called a 5-day unlawful detainer. So in the case that you serve a notice and the time that is part of the title of the notice elapses, and you've counted carefully, you've excluded the day of service, you've been careful only to count judicial days in that jurisdiction, if that time has passed, the next thing you want to do is serve a 5-day unlawful detainer notice. And again, the process service company can take care of that for you. So as I said, that's for all of the notices that I've talked about so far today, with the exception of the 7-day pay or quit. The 7-day pay or quit is actually followed by the filing of a formal eviction, okay? Now, if you've got a situation where you filed a notice other than the 7-day, and then subsequent to that, there's been no activity, you've had to go ahead and file a 5-day unlawful detainer, and there's still no activity, we're going to have to file one more thing, and it's called a 48-hour for summary eviction. 48-hour for summary eviction. So folks, if you do the math, If you add up the number of days in each of the 3 notices that would be served upon the tenant, you probably come to the conclusion that the process in Nevada can be very, very quick. That's something I said earlier in this video. It's because we are primarily a landlord-friendly and investment-friendly state. Now, I should also mention that all of these notices can be contested. And I mentioned that to you earlier as well, when I mentioned that the tenant always has a right to file something called a motion to stay. That means that a judge can grant a hearing. He can basically put the pause on the entire process. He can stop those days from being counted. He can stop subsequent notices from being filed against the tenant, and he might choose to grant a hearing. Now, once you commence the eviction process in Nevada, it is always wise to finish the eviction, to see the process through all the way to its completion, even if the tenant moves out of the property during the eviction process. Remember, somebody can move out, they can move right back in as well. And we don't want to shortcut the legal process. We don't want to have a judge throw out our legal process if we've done it incorrectly. So as I said, we start the eviction process. We always finish the eviction process. Even if the property is surrendered, even if the keys are returned, even if the tenant moves out, we always go ahead and finish that eviction process. You should also know that in Nevada, after the eviction, the tenant has 5 days to gain access for essential belongings. And this right cannot be withheld from the tenant, regardless. It doesn't matter why the tenant was put out. Doesn't matter how much rent he might owe. It doesn't matter if he has not paid the utility bills and it's caused the water to be shut off or whatever. No matter how angry the property owner or the property manager may be, remember, Nevada law gives the tenant 5 days to go back and gain access to his essential belongings. And like I said, the forms that I've covered right here can all be obtained for free. You can get them from accessclarkcounty.com. However, you might wish to get someone to help you fill them out, someone like an attorney as an example, or your broker, because these forms can be tricky and we have to make sure that we are serving them properly. I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.